Get out. Yeah, you.
All right, lawyer.
Good day, Crime Talk aficionados. My name is Scott Raish, and this is Crime Talk. Thanks for joining us. We have another great live show for you today. First, police misconduct is getting expensive. A former police officer is going to get life in prison, and what are we going to do with these parents? The young thug judge needs to recuse himself, and our dumb criminal of the day. Let's talk about it. Good day, everyone. Thanks for joining us. My name is Scott Raish, and this is Crime Talk. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, and make sure you hit that little bell for notifications. And yes, you can listen to us anytime on any of your favorite podcasting apps. Now, for those of you who watch every day, you know I don't normally do a live every day. We usually do that on our Tuesday night live program. But Frank, the man behind the camera, the man that makes all the magic happen, he is on vacation with his family, enjoying a little peace and relaxation. And so when I looked at him, I said, well, who's going to do the show if you're gone? And he looked at me and said, well, you are, sir. And I'm like, okay, I can do that. Yesterday, we had to do it in 2 takes because I didn't hit the right button. We didn't have sound the first time through. So hopefully we have sound and everybody can hear us as of right now. I hope you do. And I appreciate you all being here. Now, a couple of things I want to talk about just before we get started is there are a lot of very, very good police officers, because as we kind of go through the show today, you're going to get a theme like, gee, is Scott beating up on these police officers? No, absolutely not. All right. I would say 98% of the police officers that I've ever met, dealt with, met in courts, worked on a case with, whatever, always very, very good people. There's that small percentage that you wouldn't trust to find your dog because they're completely incompetent. But that's like any profession. All right. So as we go through this, don't think, oh my gosh, if I'm just viewing in on this guy and all of a sudden all he does is bash police officers. No, we love police officers here. Heck, if it weren't for police officers, I wouldn't have made my living as a criminal defense attorney for the last 29 years. So, and we still actively try cases. Okay. And I'm a little late doing this today. I thought I was going to do it about 4 p.m. Mountain Time, but I had a court appearance and I was getting ready to stand up and ask for a failure to appear for my client because we were set at 2 p.m. and he strolled in at 3. He goes, oh, dude, I thought it was at 2:30. I'm like, no, we were set at 2. But even if that were the case, it was set at 2:30. You're still a half an hour late, and you were this close to getting a failure to appear. Ladies and gentlemen, when you have a court appearance, this is your free legal advice for the day. All right. Show up to court looking respectable. Okay. I don't care if you have to go to the store, the thrift store, go get a jacket, go get a pair of pants. Don't come to court looking like you just came from the basketball courts. Don't look like you just changed the oil on your car, or don't look like you're going to go hunting in about 10 minutes when you get done with court. Okay. Don't do it. So few people actually show up to court looking respectful. Guess what? Courts notice it. And if you're willing to take that little itty bitty time to show up for court and look like a respectable person, guess what? The judge is probably going to give you that chance to do so if you're eligible for probation or something along those lines. So that's all I had to say today. Just one of my, try to instill a little bit of advice, and wear a belt. Wear a belt. Your pants hanging down to your knees is not a style. Okay. That just shows me that you can't pull your pants up and put on a belt. Okay. I have had many clients over the years like, dude, pull up your pants. Are you serious? You really think we're going to go into court like that? No, we're not going to do it. So let's get to our first story. Let's go ahead and open the record. And first on the docket, this police misconduct stuff, it's going to get really expensive. And how do we know this? Well, the Chicago City Council voted last night to pay $50 million to 4 young black men who were wrongfully sent to prison for decades. It's one of the most expensive police misconduct cases the city has ever settled. These gentlemen are known as the Marquette Park Four: LaShawn Ezell, Charles Johnson, LaRod Stiles, and Troshawn McCoy. Now, they were all convicted back in 1988 on charges related to a 1995 armed robbery and murder of 2 used car salesmen, Khalid Ibrahim and Yusuf Ali, on Chicago's southwest side. Now, the men were sentenced between the ages of 15 and 19 years old at the time of their arrest, and they claimed that the Chicago police used hour-long, grueling interrogations to coerce false confessions out of these men. In court filings, the men made variously described being hit, shouted at, isolated, deprived of legal counsel, and threatened with sexual abuse in prison. Well, the Cook County State's Attorney's Office dropped the charges against all 4 back in 2017 after, guess what? New fingerprint evidence came to light, which exonerated the men. Now, the Cook County Circuit Court granted them certificates of innocence in January of 2018, and a month later, they filed a federal lawsuit against the city of Chicago, Cook County, the Cook County State's Attorney's Office, and numerous Chicago police officers. Now, the 4 men said that the state's declaration of their innocence couldn't make up for the collective 73 years the 4 of them spent behind bars. Johnson, Stiles, and McCoy all spent nearly 21 years in custody for their murder convictions. Now, Ezell, who was only convicted of armed robbery, was still in jail for a decade. In that time, they said they obviously lost loved ones, experienced the ability to lead normal lives, and we are grateful to the city of Chicago has chosen to resolve our case and allow us to move on with our lives. No amount of money can ever return the years we lost to the Chicago Police Department's misconduct and caused our collective 73 years of wrongful imprisonment. The men all said in a joint statement. The men also urged the city to stop police from abusing other youth the way they had been. Their case is far from the only incident where the police accused of framing black teenagers. Now, Charles, LaRod, LaShawn, and Townsend are among the scores of kids who the Chicago Police Department had targeted for false arrest and coercive interrogations over the years, leading to Chicago's reputation as the false confession capital of the country. Now, one of the attorneys and director of the Illinois office of the MacArthur Justice Center said in a prepared statement last July, brothers Reginald Henderson and Sean Tyler sued the city. They spent each 25 years in prison for a murder they didn't commit, claiming they were victims of police retaliation by officers who were trained by or worked closely with deceased and disgraced Chicago police commander John Berg. They said members of the Berg infamous midnight crew of officers worked to put them in jail after Tyler testified in defense of yet another black boy the crew was attempting to frame for murder. The brothers' cases are still pending in federal court. Now, back in 2017, the city did approve $31 million in wrongful conviction settlements for another quartet of black men deemed the Inglewood Four. And the Cook County there separately reached its own $24 million settlement with 3 of the men and $5.6 million settlement with the 4th. Like the Marquette Four, they were teenagers when they were arrested for their 1994 rape and murder of a sex worker named Nina Glover. Each spent over a decade in prison before the court exonerated all of the men. One of the Inglewood Four, a man named Michael Saunders, was fatally shot in the head in June of 2021. Now, the Inglewood Fours case is linked to the Marquette Fours by the 3 former detectives named James Cassidy, Kenneth Boudreau, and Frank Valdez. Both the Inglewood Four and the Marquette Four named them as defendants in their respective lawsuits, with the Marquette Park Four claiming Cassidy and Boudreau in particular were responsible for extracting the then teenager's bogus confession. 3 of the officers involved in this case, James Cassidy, Kenneth Boudreaux, and Frank Valdez, framed 4 other teenagers, the Inglewood 4, just 9 months before the teens in this case were arrested. Yet these officers have never been held accountable for stealing so many young lives. Now, the Marquette Park 4 complaint claimed that, as did Henderson and Tyler's, that the Chicago Police Department has fostered a code of silence among its police that encouraged cover-ups and misconduct. And pursuant to the city's code of silence, the Chicago Police Department officers were trained and required to lie or remain silent about misconduct committed on the job by their fellow officers. McCoy stated in this complaint. And then, according to the analysis last year, settlements for wrongful convictions cost the city of Chicago $153 million between 2019 and 2023 alone. That's a lot of money for a city that already has to raise your taxes on just about everything. Anyway, the Chicago Police Department is currently subject to a 2019 federal consent decree, which activists have accused the police of slow walking, stemming from its history of racism and civil rights violations. Now, on Wednesday, Mayor Brandon Johnson, who once backed defunding the police, said in a press conference that the recent string of exoneration lawsuits and settlements for the wrongful convictions prove that progress is being made. I don't know, ladies and gentlemen, it gets pretty expensive. And of course, the police officers usually claim immunity, don't have to pay a single penny. But these false confessions, they were a thing back in the day. And I couldn't give you the study right off the top of my head, but I know there's studies out there that basically, since video has been introduced, where they actually interview the interrogation that's taking place usually in homicide and serious type cases, and now body cam is everywhere. You've seen a huge decline in this alleged police misconduct. I was talking to some police officers the other day, and they love body cam. And you know what has also gone down? Complaints against the police. When somebody complains and says, hey, investigate this police officer, they say, let's go pull the body cam video. And guess what? The officer's usually right. So, not going to condone police misconduct, but just remember, ladies and gentlemen, you want a good police department. You want them to respond when something is weird taking outside your home at night, or your family is in danger. You want someone to respond, and you also want them to be good at what they do, a true professional. And like I said, 98% of them are. The other 2%, they got to go, but the police are the ones that got to get them go before they cost the cities that they work in hundreds of millions of dollars, or at least a paltry 50 million, right? Who doesn't have a couple 50 million hanging out? Next, this former police officer is going to prison for life. That's right. A former Georgia police officer who killed a teenage girl and dumped her body was found guilty of kidnapping and murder and was sentenced to life in prison. Miles Bryant was found guilty of malice murder, felony murder, kidnapping, and a false report of a crime by a jury on July 12th in Atlanta. And he was found not guilty of criminal attempt to commit rape. And Bryant was convicted of killing 16-year-old Susan Morales, who was reported missing back in July of 2022. Her remains were eventually found in February of 2023, and Bryant was arrested weeks later. Now, before a judge sentenced Mr. Bryant, the former Doraville Police Department officer, to life in prison without the possibility of parole, he did make a brief statement. He said, quote, "I just want to apologize to everybody, to the victim's family, that is." And well, needless to say, the prosecutor wasn't particularly moved by that apology. And frankly, if you were going to apologize, you probably should have done it after a guilty plea, but I get it. You're going to face life without parole. You're probably going to get it, but probably would have meant a little more with a plea bargain. Anyway, it kind of takes away any appeal you got, since he's apologizing to everybody, including the victim's family, which means he did it. which the appellate courts will say that is an admission. So why are we taking up this appeal? Anyway, the prosecutor said that he is a monster and he wants the maximum sentence. Now, during the trial, several internet searches that were made by Mr. Bryant were shown to the jury. They included, wait for it, how long does it take for a body to decompose? How are you going to be ID'd by dental records? Well, needless to say, he was identified as a suspect after his gun was found near the body. Now, ladies and gentlemen, I am certainly not condoning anyone to harm, let alone kill somebody. But do you really think, how many times have we talked about it? Your phone is going to bury you right after your own words. And in this case, his gun is found near the body. Why is a police officer's gun near the body? I don't know. We should go check it out. Hey, let's go talk to him. Hey, we mind to see if what's on your cell phone. How long does it take for a body to decompose? Yeah, not good. Not good. Like I said, I'm not telling anybody to do that, but I mean, it's going to vary, right? Everybody knows that it's going to take long. It's going to take a while for that to decompose. I mean, really? You have to Google it? Gosh, you're lucky you're not the dumb criminal of the day, Mr. Former Police Officer Man. Anyway, next on the docket, what are we going to do with these parents? Horrible, horrible parents. So a 13-year-old boy died back in March down in Alabama. Needless to say, when a 13-year-old boy dies, the police need to investigate the cause of death. And here, the Birmingham, Alabama Police Department are now searching for the boy's mother. Serena Starkey. She is 53 years of age, and she is now being charged with murder in connection with the death. Problem is, they can't find Ms. Starkey. So how did this come about? Well, back about 7:20 a.m., that's a Saturday, back on in March of 2023, police say first responders were dispatched to an extended stay America hotel room there in Birmingham, Alabama, where Miss Starkey and her teenage son, Aston Starkey, were living. Now, Aston, who police say had Down syndrome, was pronounced deceased at the hospital. There, homicide detectives launched their death investigation into Aston's death, and the autopsy report came back revealing that he had died as a result of malnutrition and dehydration, complicated by neglect. Yep, another Mother of the Year award. Anyway, the manner of death was deemed to be a homicide by the coroner. Now, apparently the mother-son were living there in Birmingham about a year before Aston's death, and the mother and son moved often, apparently. And the 13-year-old, who was born in Florida, was not attending school in Birmingham either, and may never have actually been seen by a doctor, from what they can tell by trying to acquire medical records. Anyway, Miss Starkey has been on the run since the murder warrant was issued earlier this month. And if anyone has information about Miss Starkey's whereabouts, why don't you call the Birmingham Police Department's homicide unit at 205-254-1764. Mother of the Year award. Unbelievable. I mean, I get it. If you listen, a lot of people, they don't plan on being parents, but there are a lot of people out there that want kids, that would do anything for a kid, that would take these kids in. If you can't do it, just take it to somebody. Don't neglect them so they die of malnourishment and dehydration. That's horrible. Now this woman's going to be found eventually. They always are. And she's going to go to prison. Wouldn't it just have been better for everybody to say, I can't take care of this child anymore. Please, someone, please take care of this child. But they never do that. Next, the judge in the Young Thug case needs to recuse himself. The presiding judge over the Fulton County District Attorney, who has filed RICO charges against the alleged Young Slim Life gang member, is facing calls for his recusal after a clash between him and one of the defense attorneys in the case. Now, we talked about this yesterday and the day before. This is outrageous. So Judge Glanville is facing calls to step aside from the Young Thug trial after he held another attorney by the name of Brian Steele, the attorney for Young Thug, whose name and Young Thug's real name is Jeffrey Williams, in the case for criminal contempt for refusing to reveal how he learned of a private meeting that took place in the judge's chambers. But here's the interesting part. Can't judges have meetings in chambers? Yes, they can. They can meet all kinds of people. But when you're talking with the district attorney and the witness who's already been sworn on the stand, who's testifying, that's an inappropriate conversation. And the defense needs to be there. All the defense attorneys. Anyway, that's the big blue brouhaha as it relates to this. Anyway, the judge sentenced Steele to 20 days behind bars on Monday after Steele sought to file a mistrial based upon his knowledge of the ex parte meeting between the judge, prosecutors, and the state witness, Kenneth Copeland, otherwise known as Little Woody, and Copeland's attorney. Anyway, Steele accused Glanville and Willis's office of witness tampering during the meeting, but the judge was more focused on how the attorney learned about what was said in the meeting rather than what was discussed. Anyway, the Georgia Supreme Court has since stayed the motion, meaning that Steele will not have to serve the sentence while the matter goes up on appeal. Usually a pretty good sign when you file an extraordinary writ with the Supreme Court in the state from the district court, the judge got it wrong. And I think the Supreme Court should be asking, why are you all in there learning about what's taking place in this conversation? Why are you holding this meeting? Anyway, so on Wednesday, Doug Weinstein, he's another defense attorney in that trial, and he represents DeMonte Kendrick, also known as Yak Gotti, sought Glanville's recusal and asking that the trial be halted until the motion was heard by another judge. Now, defendants were not provided notice of the hearing either before, during, or after, and regardless, defendants should have afforded an opportunity to attend any hearing where a sworn witness in a critical stage of the trial is being coerced to testify, the motion read, and the only logical conclusion to be drawn by the willful exclusion of all defense counsel from the meeting among Chief Judge Glanville, the state, and sworn witness Copeland was to harass and intimidate the sworn witness into testifying. Now, Judge Glanville denied the motion in court on Wednesday, saying that Weinstein couldn't file a motion to recuse for a ruling that a trial judge makes and that it would require Glanville to do something extrajudicial for him to take any action. Well, Weinstein disagreed with the judge and asked the judge, "Aren't you interested in removing the cloud hanging over the case right now, sir? I'd be real careful about what you're pleading at this point in time, and you're stating that in court," the judge warned Mr. Weinstein. In response, the attorney said, "I'd be very careful if I were you." Anyway, a couple of appellate attorneys, Andrew Fleischman, is not very impressed by Glanville's remarks, saying that his words were another reason for him to step down from the case. Threaten someone who has moved to recuse you is recusable. Anyway, Mr. Glanville also refused to issue a certificate of immediate review from another judge to consider whether he should step aside, a move that Weinstein has called a legal error. The little colloquy between the two went on, said, "Okay, thank you, sir," the judge replied. Willis's office indicted Williams, Kendrick, and 26 others back in 2022 on gang-related crimes, and prosecutors have claimed that Williams is one of the founders of the Young Slime Life, an alleged violent street gang in Atlanta. Now, Williams' attorneys argue that the YSL stands for his record label, Young Stoner Life, and at the center of the trial is Racketeering Influence and Corrupt Organization Act, a federal law that allows for harsher punishments for people who commit illegal acts in connection with a criminal organization. Willis has become known for her use. Now we're talking about Fani Willis, the district attorney down there. Anyway, she's become known for her creative use of the RICO law, having used it to successfully prosecute a group of Atlantic public school teachers who cheated on standardized tests and to bring the election interference case against the former president, Donald Trump. Anyway, other attorneys showed up and argued on behalf of Mr. Steele, that's saying that they should, in fact, recuse himself. And we put up the video last night where the judge was unclear about immediate civil direct contempt and criminal contempt, right? The judge was thinking, well, you can purge the contempt if you just simply tell me who told you about the content of the conversation in chambers. And the judge says, no, you're punished, or the attorneys for Daniel Steele said, no, you are punishing him with jail, and therefore it's criminal contempt. So now he gets the due process rights, and that you can't basically do what you're doing, Judge. The judge didn't seem to get it. I put that video up last night. I was so proud I did it all by myself. Didn't even need Frank. And the judge just doesn't look very smart. He's getting it wrong. And instead of gaslighting the attorneys in this particular case, that judge should have said, you know what, you're right. I've messed this whole thing up. Prosecutor, we messed this whole thing up by going back in chambers. So guess what? We are going to declare a mistrial. But that didn't happen. Anyway, he needs to go away. He needs to go away. We'll wait and see if that actually happens. And then finally today, our dumb criminal of the day. And let me just, before I get there, let me just back up here a little bit. You hear a lot about RICO, all right? That's the federal racketeering stuff. That was made for true criminal organization, mafia, unions. It was made to come in against union thugs, okay? And that's really what it was for. Gangsters, really bad guys, all right? Let me give you an example. Let's say you and me, you being you and me being me, we go out and commit a series of, let's say, burglaries. We enter the house of another, a dwelling of another, with the intent to commit a crime therein, i.e. theft. Therefore, it's not just theft, it's burglary. And it comes on the prosecutor's desk, and he sees that the two of us, you and me, have committed 3 burglaries. That prosecutor can say, hey, I'm going to charge them for 3 burglaries, 1, 2, 3. Or he can say, I'm going to charge them under a racketeering, because this is an organization, a loosely formed organization. In fact, it doesn't have to be organized. Just a couple of people that agree what's going on. We agreed to go, burglarize these properties, 3 of them, because you need 2 or more predicate acts. So that prosecutor, instead of charging you for those 3 burglaries, I'm going to charge you a RICO. I'm going to say this is a plan that you had to burglarize homes. And we have 3 break-ins, and each one of those is a predicate act. So if that prosecutor goes to trial and the jury finds you and me guilty of those 2 burglaries, guess what? You are now guilty of racketeering. So a lot of when people say, ooh, it's racketeering, is it really? Or is it just 3 burglaries? Or is it truly a criminal enterprise that when the people drafted the statute was for true criminal enterprises? So don't be fooled, ladies and gentlemen. There can be a lot of manipulation as it comes to these RICO statutes. And I can say here in our state, Colorado, the criminal defense bar, has been challenging this for years. And finally, the Supreme Court is kind of saying, yeah, that's more of just three people committing, or 2 people committing 3 burglaries, not a racketeering enterprise. So be careful when you hear RICO. Ooh, RICO, RICO, ooh, RICO, suave, RICO. Just be careful, all right? It's not always what it appears to be. Let's get to our dumb criminal of the day. All right, jumping the fence at a Cypress Cove nudist resort and spa. Guess what? That led Mr. Milton J. Hodges Jr. into some legal trouble. At worst, he could face simple trespassing for scaling the brick wall. Any offense hardly worth noting. now that Mr. Hodges remained held without bail on at least 10 felony charges, following a one-man crime spree. Now, according to the Osceola County Sheriff's Office, it all started a little before 7:30 p.m. when Hodges claimed he was shopping in the garden center for mango and banana trees, and then other crimes followed before his arrest after the Lowe's clerk and customers chased him across the road to the nudist resort. Once inside the walled resort, however, Mr. Hodges is accused of drawing a large knife from his pants and carjacked a golf cart from a security guard. As one of the only folks wearing clothes, because it's a nudist colony now, the now ex-convict was easily spotted by the sheriff deputies who arrested him at gunpoint after he had threatened them with a knife. You can't make this stuff up, ladies and gentlemen. You can't make it up. I mean, trying to hide in a nudist colony and you're the only guy with clothes on? Ooh, that doesn't work out so well now, does it? All right. That's all we have for you today, ladies and gentlemen. Hope you enjoyed the show. Like I said, Frank can't get back quick enough. I can take off these microphones or headphones, but at least I know that I'm speaking into the microphone and hopefully you can hear me. So we got that going for you as well. All right. Thanks for watching. We'll see you next time. And yes, remember, the Constitution matters.